7112 West Okanagan Place, Kennewick, Washington, 99336, which is accounts receivable, accounts deductible, which is always This is Andy Miller's office, Andy Miller at CO Benton, Washington, U.S. Washington State Prosecutor, Washington Bar Association, which is incorporated 509-735-351. Fax is 509-736-3066. This Service Washington Bar Association for the University of Washington, Gonzaga University, also the Florence, Italy, for the compound facility in Pope Air Force Field. This is Pope Air Force Field, where the detachments for the C-17s and also the upbringing events for the detachment and also the selective services for transport of all military staff members, United States Marines, United States Navy, the Coast Guard, the Marines, Air Force, ROTCs, and all of the enlistment services. That's Army, Navy, Air Force, Marines, and Coast Guard. And that's J. Mueller Administration Office at 7114 South Union, which is the Mueller Administration Office, the Amy Mueller and J. Mueller, and also Frank Musco, and their services for implement the initiative compromise from the Social Security Office 8131, which is Social Security Office in Kennewick, Washington's headquarters, Gage, and Gate, Cincinnati, Climax, Cincinnati, 8131. Furnishing the household and furnishing the business offices, Walker's Furniture, and also paid for merchandise, desktop, laptops, active virus that's activated for Washington State Board Station. That's Andy Miller's office here in Kennewick. J. Felice, McKinnon Law Firm, Moses Lake, J. Felice at 190 East Main Street. And Mrs. Rodriguez, their services as you can see. See the increments of that download system for making sure that virus, active virus, Facebook recognition and signatures and sigmas, so they're going to make sure it's downloaded properly. From the IT technician perspective, from the Westlaw and Thompson Reuters, which represented may have you. This is the Veterans Court, Mental Health Court, and Prosecutor Attorney's Office. Of course, the Prosecutor Attorney's Office, Child Support Division, Commissioner Human Resources, the Commissioners of Human Resources, and also affidavits and systems of the corresponding Commission of Civil Service and their services. The alleged conference call and representative councils, the modem and systems, and the download systems, as you can see, for the COVID and the COVID, they have hours events. This is abundance, caution, and concern, maintaining safety, health, and public employees. Public printing press hours limited in operation, minimum 2 weeks of precautionary measure. Slow spread of the COVID-19 novel coronavirus. Spring, this started Wednesday, March 18, 2020 at 1 p.m. Prosecutor's office will be closed. In-person visits in public and staff will remain in work. Reminder of the week, someone would believe the emergency and response to call 509-735-3591, Andy Miller at CO Benton, Washington, U.S. Also prosecutor at CO Benton, Washington, U.S. Call 509-735-7316. Starting Monday, March 23, 2020, prosecutors will be only staff and essential employees, non-essential services. Prosecutors hours will be expected to reopen public April 13, 2020, normal business hours. Notification. Andy Miller at CO Benton, Washington, U.S. See? There's no increments or services and lives. In this corresponding service.
system.
Yeah, it was just, you know, there's a lot of reasons they did this. I don't like it.
I know.
Yeah. Well, it's like boring. There was a guy talking on the radio, picking up one of them, and the guy had an underlying problem, but the other 750 cases were recovered. It's just the same kind of thing. So, I don't know.
You know, you're putting in the whole shed right on the front line. Those that hey, they have a big area.
Yeah, but they have the personal protective equipment.
Yeah.
Take
So I
care.
carry this thing,
Yeah.
you know, so I'm gonna have this and I've got gloves. So, yeah.
And even, you know, I'm not worried about catching it. I don't have any more.
Right.
I'm 58 years old. If I catch it, I'll just have to go through it.
Right.
You know, just like a regular flu. But, you know, intelligent people that have these things through, so. Anyway.
All right.
Gentlemen, when you tell everybody your license, we'll get it fixed, okay? We will get it fixed.
All right. Yeah, I'll call you first thing tomorrow. You want me to call you at 8? If you're trying to wake up?
Well, just text me.
Oh, okay.
Just say,
Text out here.
Yeah, because the schedule starts at what, 8?
8.
Yeah, so if you
Yeah,
get
it's
there,
8 to 6.
if you get there at 7:30 for a
Yeah.
little refresher,
Yeah.
just text me and say I got there at 7:30.
Okay.
Instead of 8.
Sure. Gotcha. All right.
That should work.
Okay. Thanks, Mark.
Thank you.
Only took me a year to get insurance. So I talked to Jay last year, and then the processor, when I was giving him, and he said, yeah, call him the following week. And I tried to call him. Couldn't get through to him.
For who, Jay?
Jay, yeah.
Yeah,
Because he
he's-
told me to remind him, because he was writing it all down.
He's pretty tough to get hold of just because he wants me, obviously he wants me to take most every single call that comes in from the guards. Unless, you know, and then if it comes to me in regards to this, hey, I'd really like to talk to Jay, I'll say, hey Jay, this guy really wants to talk to you.
Yeah.
Yeah. That way I can deflect all the phone, because I probably get 30 to 50 calls a day. So if I can collect most of that from Jay,
Right.
then he can, you know,
Yeah.
he's working on more of that, so.
Yeah, he said, I'll put the order in for the church, give me a call next week. To follow up on it. And I did like he said.
Yeah, and sometimes, you know, he'll get off on these things, and there's other things he's taking care of, and he'll forget. He'll flat out forget, just like anybody else.
Yeah. I even said he would text, you know,
Yeah.
hey, following up on the shirt.
Well, the only reason I remember myself,
Yeah.
because I can't remember everything everybody tells me. So I got a board in the office.
Well, it was like when you were calling me yesterday, and I was talking to everything else, and then I went, all of a sudden I'm sitting there, and I'm like, crap, I should ask about the shirt. So I went ahead, and then you sent me that text with the address and everything, and I said, okay, can you remember to bring the shirts too?
Yeah.
You're coming down with the guard license.
Yeah, I said,
We'll get both.
and I turned around and said, yep, you're right, it's on my board too. So,
Yeah.
matter of fact, when I get back now that I'm ready, I'll have to erase it on my board.
Yeah. As I sent him the shirt, you know, the picture, and he looked at it, and he goes, who the hell did you know? And I said, that's just what they gave me in the class.
Yeah.
Yeah.
All right.
All right, thank you, Mark.
guys.
Okay.
Western Board Association of Mental Health Situations, since we have the download systems. Andy Miller, Mr. Andy Miller himself is in office, so we're going to have to put a precautionary accurate implement since the service. March 23rd, which would be presumption. March 18th, March 23rd possibly would be the staffed. April 13th, 2020, when business hours would be normal. So March 23rd, March 17th, March 23rd, Monday, April 6th, 2020, normal business hours will usually be extended. To get in touch with office, please contact limited configurations. This is the service implements download systems. And imperfects. Imperfect in many ways.
department.
Okay, I just don't know my case number, is it gonna matter?
Just use your driver's license number.
Okay, cool. All right, thank you. Do I need a sticker on it? Do I put a sticker on it?
Yeah, you can take one of those stickers that's the due on, call or due online with the credit card.
Oh, nice, yeah, I'll actually need one.
Yeah.
You're probably the less looking these up.
Yeah.
Hold it. All right, it's just right out this door.
Yeah, you can go out and do it.
I mean, like,
It's up there.
I'm all
All the way past the jail back to the parking lot. And it's the big metal blue box out
all right, thank you.
there, just like it. Okay. Yeah. Holders on each shoulder. All right. Daddy. Yeah. I was like, okay.
Rule 16.9, Rules of Appellate Procedure. That's 16.9, Preparation and Report of proceeding in capital cases. The clerk in trial court prepares a list of the pretrial hearings and proceedings, post-trial hearings, including any in-camera or ex-parte proceeding, specification, dates, hearing, the name of the court reporter. Last, the list shall be served by a clerk in several trial courts, and each court reporter by a clerk and trial court in each court reporter. Proceeding attorney, prosecuting attorney, Mr. Andrew Miller, someone due to Okanagan, the defendant, trial counsel, appellate counsel, and trial judge within 10 days. Entry of judgment and sentence. Appellate counsel has been appointed and representing defendants. This list and first prepared clerk of trial court shall send a copy of the list of the appellate counsels within 10 days of appointment. At the court may serve file objections to the purpose amendments to the list within 10 days after receipt of prepared by the clerk. Trial court. Objections, amendments, and the served, filed objections. Proposed amendments must be heard in trial court. Judge and settlement approval. Judge before the proceedings are held. Any reason unable to promptly settle questions under judge in the place of the judge before the proceedings were held. Once the listed hearings are settled, the clerk in the trial court shall verify the copy of the court report shall have a copy of the Supreme Court. The final should less indicate the served court reporter's financial arrangements which have been made for payment and transaction costs. The court reporter shall complete a report proceeding within 90 days. The reporter receives the listing hearings be completed within the time. The court reporter shall be no later than 10 days before the due date. Submit any affidavit, prosecuting attorney, defense appellate attorney, and the Supreme Court stating the reasons of delay. Any part of any court reporter may move an extension to the time from the Supreme Court. The court reporter shall file the report to proceedings and clerk of the trial court. The clerk trial transmit report to proceeding Supreme Court. The clerk of the Supreme Court shall provide the copy of report proceedings to defendant. 2 copies of proceedings, report proceeding, prosecuting attorney, objections, amendments to report proceedings to be served and filed within 30 days after the party receives a copy of the report. Copies of all objections shall be filed with the Supreme Court. Trial court shall settle report proceeding accordance by RAP 9.5C and D. Briefing schedule shall suspend until record is settled. The record may correct the supplement at the time in accordance with RAP 9.110. Rule 16.2, transmittal and jury questionnaires and clerks for papers in capital cases. Rule 6.2, transmittal jury questionnaires and clerks and paper in capital cases. Questionnaires are used jury selection. The selected trial court shall be sealed by transmitting the copy of the questionnaire Supreme Court, along with the clerk's papers, including copies of the clerk's minutes. The clerk of the Supreme Court, providing defense appellate counsel, prosecuting attorney copies of jury questionnaires. These copies shall remain in the possession of counsel and not made available to defendant.
His address, I'm sure, is mine.
Rule 16.16 questions certified by federal court. Generally, the Supreme Court may enter a petition of determined question of law certified to under the Federal Court Local Law Certificate Procedure Act, question of state of law that which has been clearly determined that does not involve a question determined by reference to the United States. The United States Constitution by the federal government from the Federal Court Local Law Certificate Proceedings, the Act Federal Court Law Certificate Proceedings. Generally, the Supreme Court may enter in a petition to determine question. The Supreme Court may determine its petition determines the question of law certified to under Federal Court Law Certificate Proceeding Act question. The United States Constitution Certificate Procedure means by the which the Federal Court submits a question. Washington Law Supreme Court rules provides a procedure to implement RCW 2.60, which is a caption pleading in the briefs and filed on Supreme Court. The caption of the case should be certification from originating from the United States Court. This certificate from originating from the United States Court, which is title of action. Filing in the cause be filed in index and the number of same manner as an appeal to the Supreme Court. Record shall be certified by the federal court and required by statute. The briefs in the federal court shall be designated with a file first brief. The first brief should be filed within 30 days. After the record of filed in the Supreme Court, opposing parties should file opposing court. Opposing party opposing brief within 20 days after receipt of opening brief. Applying brief should be filed within 10 days after opposing brief is served. The brief should be served in accordance with Rule 10.2. The time of filing and record, supplemental record, and briefs may be extended for that cause. Forms reproduction briefs should be provided Rule 10.3 and 10.4. Briefs will be reported to the clerk in accordance to the Rule 10.5. The cost provisions in Title 14 applicable except both parties must file cost bill and that the commissioner of clerk would be awarded cost to divide total cost in quantity between the parties. Finally, the opinion of Supreme Court certified a federal court and a mandate would issue provided Rule 12.5. Certification clerk states opinions and answers questions in Washington law submitted. Other rules are applicable is 16.117. That's 16.17. Other rules applicable. Rules 1.1, Rules 1.2, Rule 18.1, 18.3 through 18.10, and 18.21 through 18.24 are applicable in special proceedings in the Washington State Court rules, and also the Washington State guidelines, and also the Fed guidelines. Rule 1716.8, the Department and services for the parties and services. Preparation of reports and proceedings in capital cases. 16.9, the review of Court of Appeal decisions. If the petition dismissed by Chief Judge decided the court rules, the merits decision is subject to the review of Supreme Court in motion declaration review in terms of matter. Considerations of petition. Generally, Chief Judge considered the petition promptly. Time is expired for filing of the department reply. Chief Judge determines initial consideration of petitions will be contained in appellate court determinations. Determinations by appellate court, the Chief Judge determines initial considerations of petition necessary for properly decided on merits and raised in petition. Preparation of reports of proceedings in capital cases. The clerk trial court shall prepare a list of prepared trial hearings and trial proceedings and post-trial hearings, including any in camera or ex parte proceedings, specifies the date of hearing and the name of the court reporter. List shall serve by the prosecuting attorney, the defendant trial counsel, and appellate counsel and trial judge within 10 days. Enter your judgment and sentence, and appellate counsel has not been appointed to represent the defendant when its list of the first preparation clerk and trial shall send a copy of a list in each appellate counsel within 10 days of appointment. Any party may serve and severe and file objections to improper amendments in the list within 10 days after reparation clerk and trial court. If the objections amendments to the list are served and file objection proposed amendments must be heard by trial court judge and settlement approval. The judge before the proceedings are held and reason on the will promptly settle the question. Another judge may act in place of judge before whom proceedings were held. Once listing hearings is settled, the clerk and trial court will serve copy each reporter and shall a copy of Supreme Court's list and indicate date and serve reports financial arrangements, and payment transfer costs. Now, Rule 16.2, transmittal jury questionnaire with the clerk conference and capital cases. Clerk's conference and capital cases 16.2 applicable rules applies on direct appeals and criminal cases. And clerk conference upon receipt of notice of appeal of capital cases by Supreme Court. The clerk and the court shall, a clerk conference and the clerk court give the notice to the parties and the date and time and places of conferences, the name of the commissioner and the clerk who conduct the conference and the nature of issues and discussions of the conference. Attendance of the clerk conference, the attorneys of each party, and the notice requires that they attend the clerk's conference and the date time of specified in the clerk's notice. Those attendees that should read seriously consider appropriate issues intending upon the cases include limited to the settlement of the record, briefing schedule, and also the pages and limitations of these briefs, oral argument, other matters which are promoting fair disposition of the bill. Clerk's conference order result and clerk's and conference parties agree on various matters promote fair disposition of the appeal in court. Enter the order consistent. The parties fail to agree on an issue. Court will resolve an issue and enter the order. Order party during the review proceeding unless the court authorizes direct on its own initiative in a motion jury for the good cause shown of those terms the court deems appropriate.
Sheriff's Department all the way up the hall to the left. Thanks, sir. Good.
Appointment of counsel on a person and the capital cases. These comments, grounds of relief, commonly applying to stay on execution connection for the first petition for relief for their due process. Motions. It's Title 17 Washington State Guidelines, Federal Guidelines, and Washington State Court Rules. Rules 17.1 scope. Relief under the title. Person may seek relief other that decision in the case on the merits may motion provide Title 17. Motion on merits party of the seek a decision merits by motion provided Rule 18.4. Rules on the Title 17 apply motion for decision merits only extent provided in Rule 18.4. Rule 17.2, who decides a motion? Generally, judges determine the motion and also motion modifier commission clerk, and also the motion consideration of the decision, motion to recall mandate, except a motion made correct and issued a mandate. Motion to publish all those motions determined initially the commissioner and clerk in the appellate court. Reference to the judges, a commissioner or court clerk may refer motion to the judge's determination. The motion referred to the judge's commissioner or clerk will give notice or reference in all persons entitled to notice of the motions. Transferred by the Supreme Court into Court of Appeals, commissioner, clerk, and Supreme Court may transfer motion for disciplinary review, trial court decision, Court of Appeals determination. Content of motion 17.3. Motion may include a statement, name, designation, and person filing a motion, statement of relief sought, reference copies, parts of a record relevant to the motion, state of the grounds for the relief sought, supporting argument. Motion discretionary review. Motion discretionary review could contain, under appropriate hearings and headings on the order of indication. The number one is cover, the title page, which is covered, and the second, identify of petitioner statement name, designated person filing the motion. Number three, decision below. Statement decision which petitioner reviewed the court entered or the filing decision and entered filed. And the date description and order granting the denied motion made after the decision. Number four, issue presented in review a concise statement of issues presented for review. Number five, statement of this case. Statement of facts and procedure below relevant to the issue presents the review and appropriate reference to the record. Number 6, argument. Direct and constant statement of reasons of review granted with supporting argument. Number 7, support conclusion stating the precise relief sought. Number 8, appendix. The appendix containing a copy of the decision which the parties wants reviewed, copy of any order granting, denying motions made to respect that decision, the copy of parts and the parts of the recorded relevant to the motion. In addition, appendix may include copies, statutes, constitutional provisions relevant to the issue presented for review, other material which assists court determining whether the motion should be granted. C. Statement of grounds of direct review. If the motion disciplinary review, trial court decision, part making motion seek review Supreme Court, the parties seek review will also certify a separate statement urging grounds of Supreme Court review provided by Rule 4.2b and c. References form, motion disciplinary form, Form 3, motion disciplinary, Form 4, statement grounds and direct review, Form 18, motion, from 20, motion for modifying rule, Rule 6.2, disciplinary review, Rule 12.4, motion reconsideration of decision, and the review. Following and the service of motion, answer to motion, following service generally, procedure for motion. The motion were permitted. Number 1, motion filed to the party must be served on all parties and other person entitled to the notice. The Supreme Court and the decision of Court of Appeals determine the general order and whether the party may do motion in the hearing. If the party permitted in the no motion hearing, the motion be accompanied by the notice of the time, of the date, and the oral argument of the motion. Move and also contact the clerk and appellate court to determine the date available to the further argument of the motion. The motion notice to be served on all parties and other persons entitled to the motion, and before the date noted the hearing the motion, and if the motion notice hearing the court does not set a date for the hearing the motion will be decided. Emergency motion and request expedite consideration of the motion. The person representing the motion and the time notice given to the time, the date, and notice has given to each explained motion and should decide it on an emergency basis. The court requires if the answer sets the motion for argument, notify the parties of other parties entitled notice as an answer should be filed on the date at the time the motion occurred. The commissioner or clerk had decided only satisfied, number 1, that the adequate relief can be given to the motion and consider a motion in course. Number 2, the movement and take a reasonable step under circumstances to give the notice persons would have affected by the ruling sought. Emergency motion represented less notice required by Section A. Summary determination, the commissioner and clerk's services. Motion of brief answers reply and motion. Supporting papers and also the length and motion answer reply from papers and numbers of copies. And also the oral ground motion and also oral arguments. Supplement provisions, the attorney fees and expenses was at 18.1. Objection ruling review of the decision, also the motion. These pretense, which is Rule 17.6, motion decided by ruling of order. And also the acceleration disposition of review by motion. Now, the objection of ruling review on decision of motion. An aggravated person with objective ruling of the commissioner and clerk clearance transfer case, the Court of Appeals under Rule 7.2c, only the motion modifying directed to the judges of the court served commissioner or clerk. The motion modifying the rule is served the person entitled in the motion filed in the court later in 30 days ruling in motion. Now, attorney fees and expenses, generally argument brief, affidavit, and financial need, if any, were applicable for the simple provision of attorney fees and expenses. Affidavit and financial need in any person, any action where applicable, law mandates considering financial resources, the more parties regarding award attorney fees and expenses each party was served upon and file financial affidavit no later than 10 days prior date case, several oral argument days prior to date of case, oral argument, consideration of the merits, however, the motion on merits pursuit 18.4. And the considerations of the fees and answering petition review and a voluntary withdrawal of review, applicant of the volunteer 18.2, and also the withdrawal by counsel, and also the civil cases and considerations, and also disposition exhibits, Exhibit A, B, C, and that format A to Z. The cases mandate return trial. Court to refer the proceeding exhibit custody of appellate court will return to trial court. Service and filing of papers, 18.5. Service except rule inquires appellate, and also there's a proof of service. Proof of service should be made by a common service, by affidavit service mail provided by CR 5B. Proof of service appear attached to filing facial, and then also the facial mail reserved GR 17. Serving filing and the services and the computer network data conference call service equipment, signing and dating papers, computing all time, waiver and rules, extension and reduction of time, violations of rules, dismissal motions, dismissal motion party, objection ruling, celery and review and dispositions and offenses and juvenile offenses proceedings, juvenile services, increment for civil appeal statements and settlement, conference and court appeals, conference calls, equipment, ruling 18.10 forms. Any person in any form subsequent complies with rules and appendix and illustrations. Notice appeals filing appellate courts. Notice appeals filed in trial courts in compliance with Title V, notwithstanding otherwise provision, namely notice of appeal, accepting it for filing, copy of notice appeals and proof of service and filed in appellate court and appellate time in the time filed of the trial court. Motion order indigency. Parties seek and review public expenses for filed motions and indigency to trial court. Indigency should confiscate more appeals and seek for disposition orders and termination partial rights. Statements and arrangements array with the notice of appeal and party review should arrange transcription of originals or copies. Writing reports proceeding review erratically transcripts recording shall be completed in court approved transcriber in accordance procedures development administrative offices and courts. Rule 1822 statutes and rules of superseding. Rule 1.8 provides those rules superseding statute rule covering procedures appellate courts picture indicate statutes or rules suspending and superseding continue apply to case pending before Supreme Court appeals on July 1st, 1970. List of statutes of rules. Some but not necessary all the statute of rules which is suspended or superseding by these rules and listens below. These listed statutes relates to appellate procedures and some other subjects. Superseding only relates to appellate procedures. Listed statutes and once of the rules, specifications, statute controls, and parts rules. Statutes supersede only relates to other rules. Other rules are superseding, no longer effective. Statutes of rules superseding SR 15, ROA, I1 through I through 67. ROA number 2, 1 through 11, number 2 through 4. CAR 15 and 24. CAR CAROA 1 through 66. CR 62 C, D, E, and G. CR R 7.4 D and 2. CRR 7.7. RCW. RCW 1.12.040, RCW 4.88.260, RCW 2979.170, RCW 49.60.260, RCW 04.010, RCW 5.48.050, RCW 29.79.210, RCW 50.32.130, RCW 2.04.160, RCW 6.24.110, RCW 29.82.160, RCW 51.52.110, RCW 2.009. Next one is 2.04.170, RCW 7.36.040, RCW 3.3.090, RCW 52.34.090, and these rules of 18-point identified statute of rules in force in July 1st, 1975, were per superseded of these rules. These might be other statutes. Task Force did not find the statutes indicated since July 1st, 1970 in conflict with these rules, and statutes or rules have been overlooked and questions whether or not superseded governed by Rule 1.1. The statutes might supersede the part of retaining the part. Statutes supersede only if they relate to appellate procedure. Further, portion of the procedure statutes might be retained in a particular rule expressly states in statutes. For example, RCW 8.04.070 superseded to appropriate method of review retaining it in for specifies allowed the seeker review, and rules 2.2a4, 5.2d, the 10 relation between these rules and statutes next discussed deserves classifications. RCW 24.32.360 supersede except rules and portion restricting relief available under Rule 8.1 and 8.3, RCWR 46.20.270, staying execution of sentence pending an appeal is retained. RCW 48.31.190 restricts relief available under Rule 8.1 and 8.3 and is retained. RCW 50.32.130 and RCW 51.52.110 affect the relief available under Rule 8.1, 8.3 and retain except the extent of statutory requirements and pertinent and jurisdictional area. RCW 59.12.200 affect relief available under Rule 8.1 and 8.3 and is retained. RCW 84.64.120 is superseded and relates in motion of appeal, retaining the effects relief available under Rules 8.1, 8.3 except the extent statutory requirements pursuant to its jurisdiction. RCW 85.05.130 supersede except for the 30-day time limit, seeking review, which is the event corresponds to the rules. The position taking respect to statement, no bounds shall be allowed in such appeals because of the task force is unable to determine the meaning of this statement. RCW 85.06.130 superseding except for the 30-day limit for seeking review, which is the event corresponds to the rules. The position is taken to respect to the statement, no bounds are required. Such appeals become the task force unable to determine the meaning of the statements. RCW 90.03.210 affect the relief available under Rules 8.1 and 8.3 and is retained. RCW 91.04.325 supersede except the 30-day time limit seeking, which is the event corresponds to the rules. Positions take respect to statement upon the appeal and bond shall require to stay. No stay shall be allowed because the task force is unable to determine the meaning of the statement. RCW 10.77.130 relates to the record review and supersede. RCW 10.77.230 relates applicable orders and judgments and superseded. Rule 18.23 mail addressed to appellate courts. All briefing papers submitted to Supreme Court and Court of Appeals and filed consideration case and addressed to the clerk, appropriate clerk, and clearly show the brief, the paper itself, and the cover letter the name of the court, which a brief paper being submitted, caption to the case, the docket number in the case appellate court, and also the docket number in the case trial court, name of the trial court, pleading where consideration time of field, Supreme Court, the Court of Appeals and time of field, and the Division Courts of Appeals, and the Supreme Court. Rule 18.2 for statutes of references. The reference in the rules have been adopted. The Supreme Court references are solely those adversity task force on appeals rules. And that's task force on applicable rules. Appendix of the forms. You notice the trial court decision. On the left-hand side, it says Superior Court of Washington from that jurisdiction of the county, Benton County, Franklin County, any of those counties, which with the series is the name of the plaintiff, and also the trial court, the notice of the appeal court of appeals, the name of the defendant, of course the notice of appeal of the defendant, the name of the parties seeking review, plaintiff and defendant, seeking the review of designated appeal, court date, and describe the decision of the party decision which parties wants reviewed. For the example, judgment, paragraph 4, the marriage or dissolution decree, enter of the date decree, or whatever you have for the copy of the decision attached to the notice and date. The name and address, telephone number, Washington State Bar Association membership number, and attorney appellate name, address, and counsel for each party shall be listed here. Criminal cases, name, addresses, and also defense shall also be listed here in Rule 5.3c. Amended effective September 1st, 1994. Notice of discretionary review. We got Superior Court of Benton County, name plaintiff, and then also court notice of discretionary review. Name of defendant, Court of Appeals of Supreme Court defendants, the name of parties seeking review, the plaintiff and defendant seeking review, designated appeal court if it describes decision, court decision, which party wants review. For example, order denying discovery, paragraph 4, restraining order or entering the date of the entry, copy decision attached in the notice. Signature on the also with the attorney and plaintiff of the signature and co-defendant and defendant, name and address, telephone numbers, and all State Bar Association numbers. Their attorney, petitioner, name, address, and counsels for each of the parties should be listed here. Criminal case and the name of cases and defendant should be listed here. That'd be Rule 5.3c. Amended effective July 2nd, 1976, September 1st, 1995. Motion of discretionary review. Rule 6.2, review of the trial court decision. Rule 13.5, review of court appeals and the interlocutory decision. Rule 17.3b, content of motion, appeal of court, Supreme Court, Court of Appeals, decision of the state, Washington. The title of the trial of the court proceeding, the parties designees in 3.4, for example, John Deere, Evergreen, John Deere, Moline, Illinois, John Deere Green, RDO, versus Mary Doe, petitioner, or Henry Jones, defendant. These are just examples. Mr. Donald Jump, respondent, and also the services for respondent and services in the petitioner, and Henry State, United States of America. Motion, discretionary reviewer. Name petitioner attorneys in motion discretionary review. Address, telephone number, first and last, Donald Trump, phone number, administration, Air Force One Administration Office, Washington Bar Association, social membership, petitioner attorneyships, identity of the petitioner, Donald Trump, and also administration identity of the petitioner, first and last name and address, which is red line, residence area, which is being updated, uprooted, and landscaped already, and beds and terminates and beds and first and last name, and also hazmat services in terms from the torn internal flooring services already been done here in Kennewick, Washington, and that's Cluck and Fry's Red Lion, and also AT&T, Verizon, AT&T, and also don't forget Verizon, AT&T, and other services that are having sponsored at 712 West Okanagan Play, the underground body system into the basement that occurs to the active Cascade natural propane lines that billions and billions of feet that's been destroyed, connected to Cimaron 5 INC. And Cimaron 5 owns an entire billions of footage of damage, and the confiscation for the service identity of petitioner, the name and ask court review of the petition parts decision to sign part B or motion. The services which they say in black and white, the name, first and name, court and recipients or views, the expression reviews of services of watching this man pronouncing their service of striking this individual, and this individual is taking all these internships, the most powerful man in the world, all these black belts, these red belts, these specialty forces down like sissy boys, and discretionary of the issuance. It says preferred of view. They always say this or say that, and we have commonly the reviewed individual common core motion of discretionary review. It says 6.2. The review trial decision, Rule 3.5. They run in the vehicle, into the vehicle, and with the device, all their services, and they pretty much don't do their discretionary report of making up things. It says the respondent. The trial court proceeding prior to signing Rule 3.4. It says the Form 3 motion tertiary review. It says the issues presumes to review defined issues the court asked the side to review granted, which they never showed up. The Part 2 in Form C, and that's Carol J. Benzel, the judge, and also the staff members there, and then corporate services, which is protected in many ways, shapes, and forms. She gets her class services, her class permit, and her services through that discretionary in the property, and also the entire property, and that's Ajmer Singh Nijjar, Donald Trump. See the services that I have, it says the name of the petitioner, of the attorney petitioner's address, telephone number, his first, last name, address, phone number, and also the corresponding landline phone number, Washington Bar Association member's number, and petitioner attorney identity of the petitioner, and ask and accept the review decision parts of, you can see the AstroTurf and also the outside and tumbleweeds, which that property belongs to Ajmer Singh Nijjar, and that's Donald Trump and Ivanka Ganja and administration of 1099 forms and processing the 401k forms. The conclusion on the arguments, the statements and the cases, the right and the statement procedure below, and the fact the statement fall, which he didn't fall. It says the statements were brief on containing material relevant in motion. The motion, the direct count appeals decision. He carried him all the way into the administration sidewalk and also in the processing, carried him all the way into the police station and all the judge's chamber in the Washington Bar coroner's office, dragged him all the way into the Part 3 Form C and this motion of his services for the decision reference guide, made portions trial courts, portions in the trial court, and placed in appendix certified copies are necessary in the portion of the trial court's recording place in appendix, the portion to identify the reference pages appendix and portion of the record appear. The argument should be short and concise, supplemented by the authority. Argument should be direct consideration, accepting review set by Rule 2.3b, review of trial decisions, and Rule 3.5b for the review and decision of court appeals. Conclusion, and this conclusion is number F. That's A, B, C, D, E, F. Court, Superior Court here, and also the federal court system discretionary districts 1, 2, 3. Tacoma, Spokane, and also Seattle, and here, and also Kennedy's exposition and the equipment that we have upstairs at 712 West Okanagan Place confronts the argument with a review and discretionary acceptance. Argument should be short, concise, supported by authority. Argument should be directed. Consideration, accepting review set. Rule 2.3b, review trial court decision, and 3.5b for review and decision in court appeals. And number 5, number A, courtroom, number B, courtroom, number C, courtroom, number D, courtroom, number E, courtroom, number F, courtroom. For the state relief sought in review in our grant example, in these courts accept a review for a reason indicated Part E, modifying the retaining order petition. And this permit defendant use assets to pay fees and costs incurred defending plaintiff suits for conversations. Now the date respectfully submitted, there's going to be a signature, the first, the last name, this Mr. Andy Miller's signature, and Mr. Andy Miller's signature, Donald Trump's signature, and also administration. Mr. Donald Trump writing a check to Felix Barela, and that total amount paid for at 2000, 1990, 1991, 1992, 1993, 1994, 1995, 1996, and it says the signature responded to an appendix, see Rule 7.3, B3 for merit to include within appendix, Mr. J. Mueller and also Manny Miller, and their signatures for the checks that are signed on, and there corresponds in the FDIC, Social Security Office. It says attorney, the identities and parties appellate. First name, address, telephone number, Washington State Bar Association number, attorney fee, and filing brief petitions amended September 1st, 1984. Brief of the appellate of Rule 10.3 on, which is the Form 5, form to cover the title page. And that number 5 is usually discussion of pilot briefing writing. See latest edition in Washington State Bar Association Pilot Practice desk books. These desk books, desktops, and also laptops, and also the servers and towers and monologue for the Microsoft programs in the cover unit. This Washington State Bar Association Pilot Practice desktop, and there's no practice, it's because of the permanent desk book. The table, and that's the table of contents, which introduction to options on that service for 1, 2, 3, 4, 5, 6, and 7. Those 7 service and introduction optionals, the assignments of error, number 1, number 2, number 3, issues pertaining arguments of errors 1 and 2, statements of the case, summary of argument, the argument dividing into separate headings. And these separate headings has a list of each separate heading and give you a page for each begins. The conclusion and also the appendix. And this list of separate items and appendix give page where the item begins. Table of authorities, table of cases. These cases alphabetical arguing, caution complying rule 10.4G. And that's 10.4 grams. That table of contents approximately is 10.4 grams. Again, the pages and numbers where each case appears on each brief. Watching case may first list alphabetically and order cases following and listen alphabetically. Constitutional provisions. There is constitutional provisions under which provisions appear in constitutional page numbers are each referred to the brief. Now statutes, and statutes and lists and statutes which would appear in RCWSC, which the page numbers were each referred in the briefing. Common names, statutes may use in addition in the condition of the numbers. Regulations and the rules. Here the regulation court rules are graphed and also grouped in rules. And these appreciate the categories listed in numerical orders in each of the category pages, number of each referred to in its brief. Other authorities, here are authorities of page numbers where each are referred to the brief. Not from the citation CGR 14D, introduction, petitional, and these are optional, may be included as separate sections of brief filing part discretionary. Introductions net to contain citations and record authority. Number 2, assignments of error. There are separately state numbers which assignments of the error required by Rule 10.3A and G. Example. Number 1, the trial court error entered an order May 12, 1970, denying defendants' motion to vacate judgment, entered in May 1st, 1975. The trial court error in denying defendants' motion to suppress evidence by order entered on March 10, 1975. Issuance pertaining assignments by error, and that's title and enclosed right above the table of contents and authorities and table cases. It's going to be a law title that they did issuance of caps. First caps, big caps. Middle would be small cap 2 assignments. Middle above, small cap, and big is error. Issues pertaining to assignments of error constantly define the legal issuance questions from which the appellate court is asked and decide the number of each issuance list after each issuance assignments by which pertain the issues, the assignments of error which pertaining to issues proper phrasing, and issuance in the important, and it should be phrased in the terms and circumstances, and these circumstances are of the case. Without unnecessary detail, the court should be able to determine what case about the specified issues court will be called upon to decide merely reading issues proceeding for review. Example of issues proceeding review are, these are, does an attorney without express authority? Now, does an attorney without express authority from his client or have unappealed authority to stipulate or carry of a judgment against a client against a party of settlement which limits the specification of a judgment specified properly of a client? Is his teeth missing, or is his hands, did you break his legs so he can walk to the sidewalk or walk to Andrew Miller's office? Because this is assignment of error. That's just example. Assignment of error is like you show up with all your toes and fingers and you have no you're disabled, you're in a wheelchair and you have no teeth, and you're going to surgery and they go to surgery and your teeth are gone and you can't even talk. So that's just an example of issues presenting a review of R. Does an attorney without express authority from a client have implied authority to stipulate the entry of the judgment against the client as a part of settlement which limits the satisfaction of judgment of specific property of client? Is this man on steroids or enhanced steroids? Can we promote some video recording information of this individual taking his blood and make sure and make material witness of blood pulling out of his vein and make sure that all the contents of that blood vessel and the surfaces are in a container, and examining possibly make sure there's nothing negative or anything, any antibiotic steroids or any, and we can probably throw some havoc, some screws, some bolts, and the auger, or the John Deere Evergreen implement, which is $1 million equipment, $300,000, $600,000, $900,000 equipment, and they're going to put some right in the auger where you can just bind up the equipment, mess up the Microsoft, the metal equipment, mess the auger, the command shift RDK Stellar Microsoft program, the jet satellites provide the jet propellant satellites to project Bushnell and Wall Street, and that's just example. Example, if she's presenting review, is that an example? Because this is an attorney without expressing authority for the client. See, if there's no client, there's no case. So when there's no client and there's some way disabling client in the services, this example, this is just a small example, stipulating an entry of judgment against a client and part in the settlement issue. This is an example. Or defendant was arrested in traffic offense or held in a jail for 2 days, another example. And the police apprehended and impounded defendant's car, conducting warranties of making, fabricating, opening container and closed container, and then it's in plain in view and none of other witnesses. Inventory search of defendants and discovery. This car and C stolen property in trunk, like Red Lion or administration office or the FBI CI Academy at the federal courthouse, where you just park all his Air Force equipment in his wardrobe and just let it have detained material witness pour in at that simultaneous moment. That's just examples of issue presenting review at the attorney discretion or lawyer discretion, or lawyers or doctors or surgeons or administration officers in processing information and influence, flying in a shot police officer from downtown Moses or Othello or Kennewick, Richland, or Spokane Mesa or Basin City, or any of the parameters of Franklin County, with Adams County, Franklin County. Franklin County is Benton County, so Adams County, that is called a defendant arrest in traffic offense, held jail 2 days because of the outstanding traffic warrants. And there's no warrants for his arrest, apparently, because there is no warrants because he called the police on him at the jail. And he called the state patrol officers and the FBI Academy on him because he was a lying piece of shit. Did you search and seize or violate defendant's rights under the Fourth Amendment and also the Constitution of the United States of America that's on him? And that's Article 1, Section 7 of the Constitution of the State of Washington, which is driver's license appendix and also Class A and first and last name, and also the arraignment of this. This is an example of issue presenting review. It's just an example. Attorneys will expense of authority of this client, implied authority stipulation entry judgment against a client against previous settlements and certification judgment specifying properly with Mumu Ganja and Ivanka and Donald Trump in the parking lot. That's an example. Yeah. That's a prime example. It's a perfect example. You hit this guy once, you hit this guy once. It took 10,000 of them, and they couldn't even take him down. He was standing. Is that all? And then they make up fabricated RCJSWs, and it says the summary of judgment right here. It's on write the statement of procedure below. In fact, relevant to the issue presented for review, the statement should be argumentative, or the second case, or small caps. Every factual statement should be supported in reference to the record. See Rule 10.4F, the proper abbreviation of record, summary and argument, and this is, remember, entitled Indemnities, this is optional. This is an example. When this is the argument, the next one's argument. Argument entitled hyphen. Hyphen, the argument should orderly be separated and stated under appropriate headings and each presenting for review, period. Long arguments should be divided, subheaded, in the subheadings, period. The argument should include citations, legal authority, reference, relevant parts, and record, period. The court ordinarily encourages concise statements of status review of each statute. Conclusion. Here, state precision sought date. Respectfully submitted, signature. Nature of the attorneys, or power attorneys, bars, bar association, multi. Attorney, a defendant responded, or petitioners, Washington Bar Association membership member. And that's conference call, equipment, and services that increments on those services. And definitely not serving in indigencies, and definitely a panel of private council members in their service. And this is just an example. This appendix contains table of contents, and then go to number 1, introduction, which is your optional, see Rule 10.3A3.1. And that's within parentheses. Assignments of error, number 2. Assignments of error is number 1, number 2, and number 3. Issues presiding assignment of error, number 1, number 2. Statements of a case, number 3. Number 4, summary of judgment, number 5. And parentheses, after the argument divided into separate headings, list of each spree. And this is not a spree, but a separate heading, giving the page where each within period and parentheses. Conclusion. This is appendix, next one. And this under the appendix, A1. A1 steak sauce. A1 marinated bear, and that's bear batter, or any shrimp, jumbo shrimp, tiger shrimp, and baby shrimp, and in administration the bear batter. Also, morels from Yukon, Oregon, the gigantic elk that loves crossing the area, especially when you lay in a sequentially in a multi-fill with morels, where you can put shake and bake and put thousands upon thousands of pounds of morels, and the path of elk. And you take this elk and you smudge it all and wipe it all over your body with aloe vera, and your natural resources, habitat of your services, elk will be spontaneous in the trail mix, and you'll have a Constitution provision agreement, pretty much, with your permit and your service on your land. Of course, it's all your land. You got all the elk on your land. So it says here, Constitutional provision order, which provisional appears, Constitution with page numbers where each is referred to the brief. Now, this is just a pertaining assignment error. This is just a defendant. This is just examples of presenting a review. This does for the attorney with an express authority for his client. Implied authority to stipulate entry of judgment against his client as part in it, and also somewhat lists certification judgment to specify property of the client. So the morels are organic. It's a plant. It's a Washington Farm Bill. As long as you pay 18 years in advance in your farm bill, you got, this is 2020, so 2030, you got 18 years of 2038, whatever, 2038. You got till 2038 to, this is an example of issue presented a review of a statement pursued below facts relevant issue presented to for review. Statements should be argumentative, factual statements supported by reference to records, of course. See Rule 10.4 F, proper abbreviations of record, and that's a summary of argument. An argument should ordinarily be separately stated under appropriate headings for each of the presenting for review. Long arguments should divide into subheadings. Arguments should include invitation of the legal authority in reference to revealing parts of the record. And the court normally encourages concise statements of standard review to each issue. Now, this can carry on all the way to the 1 mile long stomach valves that which is your conclusion. Now, your conclusion is the states of precise relief sought in the conclusion, respectfully submitted signature, the name of your attorney of your appellate respondent's petitioner, Washington State Bar Association membership number. That's online. Washington Bar Association, you're online. That's online. Everything's online. And it's on Form 7, Notice of Intent of your pro se supplement briefing. Number 8, Form Notice Appeal from Court Appeals Decision, published Note Form 8 concerning re-signing Rule 3.2b, and also September 1st, 2006. Petition for review is 3.4d. See Form 5 from the cover, which the title page. Table of contents from 6, except notifying names of parts of brief, corresponding names of parts of petition for review. Table of authorities, identity of the petitioners, and the name, and ask court accept review of court appeals determining. Review deciding of Part B in these petitions. Number B, Court of Appeal decision, identifying. the decision and parts of decisions, the UBI number, business UBI, whatever the case might be in these Court of Appeals, which party has irrelevant, which is reviewed. Party wants to review any of this information because it's online. The motion reconsideration copy decision is an appendix of Parts A through a copy of order denying press petitioners. Motion of reconsideration of appendix pages A through whatever version of that is. Number C, issues and presenting the review, and that's presenting a review. Organizing, prepping, contents, and Microsoft Equity. This is any of these SWA services or any of these Microsoft windows and pertaining to information and recovering information from the day of Jesus Christ Almighty, Rome, the earth of Almighty, and the disciples, and also the services where they have increments of serpents, lasers, he, she, or her, whatever the case might be in the argument of case might be, because you're in front of a judge and pertaining your contents and emptying contents and remains of your weapon, whatever the case might be. But put you at this point. Issue and presenting for review, define the issue in Supreme Court, asked to decide if a review is granted. See the section portion part A of Form 6 for suggested for framing issuance, presenting for review. Now, identity decision number B, go back to B, because you got to reflect on the decision, party decision of your Court of Appeals, because what the party wants to be reviewed. Any party, date, file, dates, orders granting the denying a motion or consideration, a copy of decision in appendix of page A through a copy of the order denying petition motion considerations. Now see, define the issuance the Supreme Court asks to decide a review is granted. See, second portion, part A, from suggestion from framing, issue, and review. Number D, state of the case. See, part 3 or form 6. E, argument why review should be accepted. The argument should be short, concise, directed, consideration, accepting, review, set rule 3.4b. Argument generally in part of that origin. Form 6. Argument may be preceded by that summary, and that's number F. A, B, C, D, E, F, and that's the superior and processing information in your conclusion here at 7112 West Okonock Place. Corporate information, also information is 509-736-3006. Has a recovery system data, and anything is erased, anything is downloaded and submitted and erased. Discretionary report shows on F. Statement of relief sought and review granted. See Part F. Form 3. Date, respectively submitted, signatures, name of the attorney, attorney from petitioner and respondent, Washington State Bar Association membership numbers, appendix. Rule 3.4C9. For materials to include with appendix. Amended effective July 2nd, 1970, September 1st, 1970, September 1st, 2010. Form 10, cost bill. So Rule 4.4, Supreme Court, Court of Appeals, divisions, and state divisions, trial court proceedings, which parties designee of the 3.4, and the cost of bill, the cost of which is, that reminds me, that's Benton County POD. Benton County POD is I-82, Washington State Patrol Unit. So if you can run from Oregon State all the way to state of California, all the way from Santa Barbara or Santa Maria or Los Osos or Casadero, and go over the San Francisco Bridge and get on the pull-up bar and exercise your rights of activities of exercising the whole state of California and all the 5 borders, because of course you're standing and there's only 10,000 of the individuals that supersede in their way of making themselves as portraying themselves as staff members or a licensed individual in many ways. As you can see, he's imprisoned in the federal unit, and they call him a retrieval recovery unit system individual that's been put in the system and exposed to the community, in which you can see the California ordinance all the way into Washington State ordinance. They compromise and download the system and recovering information that it can be deleted and downloaded and submitted to Andy Miller at Mr. Andy Miller's office upstairs. The false contents of your information for the appendix of these forms, the forms 12A, finding the services which is no identity at all, presenting the name of the attorney in part, presenting the order of Washington Bar Association membership number, amended effective September 1st, 1985, June 21st, 2005, September 1st, 2006. All those active and also responded information is prudent for your filing. Your fee is waived. The filing of waive. You're entitled to your council review wholly public expenses, review, dictionary, council provided expenses, detailed below, paid and review accepted for your always being there on, and also in having the conference calls correspondent activated. That's RAP 15.2. Consultant system appointed council review and prepared record. Name of the entitled entities and public expenses at that time of appointment services, which the original document is can be duplicated or scanned or put it on a laptop and processed and left on the counter. And those counterparts and the counter chief just preliminaries of receipts and transactions of the dictionary, FDIC, and also of course the Federal Reserves, which issues all the paper and making paper of the casinos, which gives you the right to statutory attorney fees, preparation of origin of copy of the reports and proceedings, copies of clerk's paperwork, transmittal record of review, on review, expenses occurred in suit proceeding and decision of the trial court, identify, charges in appellate court for reproduction of briefs and petitions and motions, identity, and separately state of the charge for each, preparing of these 50 pages of original documents and filing fees. And there's a total at the bottom. That UBI number effective UBI Washington State, or UBI number in use of Washington State, and then the services they have, the items expenses allowed to cost Rule 14.3 reasonable expenses actually incurred and reasonable necessary for review. The name of the party, and should pay the cost at the effective date, which is paid, and with a signature and compromise in that signature, the attorney of appellate respondents and petitioner, the name, address, telephone number, Washington State Bar Association membership number, and attorney. Now you have platinum, and there's platinum, and there's premium, and then whatnot. And those services they have, there's a babysitting fee for $15 for 2 hours. And the issuance presenting for the review is defined for the Supreme Court decided the review of grant this number C. It also follows cost stands for D, A, B, C, D, E, F.
They're not open down there. No. Envelopes are up here on the table, you can grab one, and then take it out to the middle box out by the park.
Okay.
Okay?
Okay. You said the.
Yeah, right on the table over here.
Okay.
You're okay.
Now, Form 13, motion for the order for the
Fill it out
Supreme
there
Court
and
of
just
Washington
take it
from
out of
Benton
box.
County. The name of plaintiff's name, defendant decides the motion ordered in the criminal, juvenile offenses, dependency and terminations, and then commitments and civil contentments, and corpus, and an appeal involving the constitutional and statutory rights of the councils. Any of these services on these of the name of plaintiff under defendant responds petitioner and files the notice of appeals above referred criminal, juvenile offenses, dependencies, termination, commitments, civil contentments, corpus appeals involving constitutional and statutory rights, counsel cases moves, and also move courts and orders of initiating authorizing expectation of public funds, which is private counsel. Those facts do not apply. Private counsel services and the prosecution of appeals wholly public expenses and partially and public expenses. These deductions are made in support of motions. These dates and defendant respondent petitioners and Washington Bar says attorney and defendants respondent petitioners on the bottom certificate is very also certified as follows. This defendant respondent petitioner appeal judgment was entered in above title. Previously being found indigent or non-indigent, their services that have been changed in financial, which is uncalled for services for the service increments. They ask for the court of order following provided public expenses and filing fees in preparation, brief and preparations, verbal reports, proceedings, and preparation of necessary clerks. Authorize the courts obtaining certifications and also information regarding a financial statute from banks, employers, and individual institutes from report. Number 5, immediately report the grant. And also, the grant, there is no grant, it's called the report to the court. Any change in financial statute merely affects the courts of finding. And also, number 6, a review of good faith. Following of the statement is the nature of the case of the issuance of sought review. Number 7, in the Government Rule 5.2c only, I have the constitutional statutory rights to review it to the public and to expenses the issues I want to review, probable merit. During the statutory constitutional rights and brief and describes the merits and appeals sought. And also, I certify under penalty and perjury under laws of the state of Washington, foregoing is true is correct. Mr. Donald Trump's signature, Andy Miller's signature, and also administration rights. Mr. J. Mueller and Amy Miller's signature, and also the services they have for the continuing the incubated Form 12A and the incubated Form 13. Incubated 414 invoice court reported indigency, that does not apply in those services. So the statewide Washington Board and all services and appendix, and Mr. Patty Marion Canwell and Mr. Donald Trump, their service increase on the appendix form, are the attorney for the Washington Bar Association number certifies on the very left-hand right side. It says certified in the day of 2020. These court companies and statements of arrangements serve the following in a manner indicated below. Counsel for U.S. United States mail, hand delivery, counsel name, address, counsel, name, U.S. mail, hand delivery, counsel for name, address, court reporter name, U.S. mail, hand delivery. Amended effective September 1st, 1994, December 24, 2002. From 15A, notice filing vibrant report of proceeding in the Court of Appeals in the state of Washington. Notice filing vibrant report proceeding RAP 9.5. Declaration of Independence. The name, the first name, the court responded to transcribe filed vibrant proof responding 2020 for the following dates providing a copy of party arraignments of this transcription. Transcript of your, of course, your high school diploma, transcript services for your department license, DOL, abstract record, and also the running track record of you running the entire state on foot, of course, and on highway. This transcript carries out the computer generated, which is on the desk at the Washington Bar Association, Annie Miller's office, making sure that birth canal breach of coming out of the vagina, making sure intestinal and fine films are not wrapped around the neck, suffocating Mr. Felix Barela coming out through the urethra. So these con artist fools will never get away with certificate of service and certifying the day of 2020 caused by the true correct copy of the notice to be served following in the manner indicated below. The United States mail hand delivery, and that be Tri-City Herald, with his esophagus and a blood jaundice looking kind of fat, plumpy Felix Barela, weighing approximately 100 pounds that coming out of the vagina. And urination and bowel, the stomach is about 100 pounds, but approximately there's pounds to the ounce. There's 12 ounces to a pound, so that 100 pounds, $1 for each pound is $100. And that eating the body of a baby at Tri-City Herald. Why services? Why unlimited services? Apple services. I3, I5, I7, I8, Apple services. Any discretion, U.S. mail hand delivery. U.S. mail hand delivery, U.S. hand mail delivery, and that's 1, 2, 3. Certified on 2020 caused by a concurred notice to be served following the name of indicated individuals. Form 15B, Statement Arrangement Appeal Dispensation Disposal Orders of Order Terminating the Parent Rights. Form 5T is a series of clerks of appeal addiction, and the pain and anguish of these individuals being suffered. As you can see, Hillary Clinton's people that she tortured and mayhem, also the services, the Supreme Court services, the appeal service, the Tri-City Herald, increments of service, people that live on my property and use my toilet, use my kitchen, and discretionally pull out a gun or weapon or banish a weapon when they're influenced alcohol because they like to party at the gigantic Mr. Chip or Miss Bodacious or Mrs. Queen Bee of whatever state she moseys through my land. It says Form 4. Statement of grounds of direct review. Title trial court proceedings with these parties is and Rule 3.4. Statement of grounds for direct review by Supreme Court. And this gigantic pile of paperwork, all these women want all these stipulation papers done immediately now. But the form of statement of grounds says direct review first. See, this title of trial court proceeding are part of this assignee of 3.4. Statement of grounds for direct review for Supreme Court. The name of parties seeking direct review of described decision part of decision on party wants review, entered by the name of the court and the date of entry. And the issue presented review are the state issue presented review part 2, Form 6 for suggested framing issue presented for review. The reasons for granting direct review, and this is briefly indicated, argue grounds to direct review. See Rule 4.2. Respectfully, signature, name, address, telephone number, Washington State Bar Association membership number, and attorney. And also the discretionary of this app. It reminds me of the Benton County PUD wants $5 million because discretionary, they can't pay for the services because they don't got no money. And they don't want to pay for it because they have no attendance record. They don't have a reckless record that you can walk in any bank in a vault and deposit the inquiries with a fingerprint and recognition eyeball sensor when the individuals are asking why hands and heads and body parts are in a refrigerator. You got children all ages of walk and life. And that was basically she touching body parts in the refrigerator. It's a simple refrigerator that's and it's open doors, open to the public, and it's just sitting there rotting away. There's no maggots in there. It's pretty much refrigerated, so it's pretty self-explanatory. Maybe they just mold it and put it up on the front lines of the Army and the Navy, Air Force, Marines, and all Fallujah to sea, and the services for increments of northern provenance, and also the services for all oceans to bind their contracts and bind and import-export and their services, feeding the siblings, and also eagle regurgitating all the bile out of its stomach into the siblings and have them eat their breakfast, lunch, and dinner 3 times a day. This individual seems to play a sad role for the Benton POD, or the Franklin, which is nuclear power ordinances original in Washington, of course. These internet systems, device services are very applicable on your Apple, your XR, or your 10, and your also, of course, your generation 10 and 11. Now, this business UBI effective number is called for you're online. It's 7 days a week, and also after any time of moment response, this says see about your info. It's right online. We activated appendix form is what it is, the ground 5, form 5 for the stationary multi-billion pound factor. In with the garbage, out with the garbage, out with the garbage. Effective UBI numbers and first and last address, and first name, last name address, and inquiries are have to be on the updated affidavit and appendix and forms, respectfully submitted with the signature and also name petition. That's Apple, and that activates your UBI number, which gives you the arguments of review, the conclusions, the courtrooms A, B, C, D, E, F, what discretionary. You also have a walkway fence for also to the tunnel to the open community, because the community is open to courtroom. They have this discretionary issuance presenting a review. Define an issue court asks to decide the review granted. See Part 2 of Form 6, suggested framing issue and presenting for the review, as you can see. Benton P-U-D. That's B-N-T-P-U-D. P as in power, U as in utility, D as in, how would you say, derivative and anti-derivative and slope productions, like a brand new gigantic 18-hole golf course with the walk-in and walk-out basement for importing and exporting your file systems for issuance for presenting a review. This Form 4 Statement of Grounds for direct review goes to the Supreme Court. Supreme Court, the state of the review, the trial court proceedings with practice INE, Rule 3.4. Goes a Statement of Grounds for direct review for the Supreme Court online. So we're going to have to do this again, see if this works. B-E-T-O-N-P-U-D. And the P, the U, the D. It's online. There it is. And then it says BenPUD with the logo sign on it. 2,459 likes. 393 people are checked in there, meaning they're online now. So the BenPUD with a logo sign and the job, and select your job title, of course, because when you do your job title, the UBI number on your effective UBI number of the ownership and identities, Supreme Court of the State of Washington, the name of the party direct reviewed, description of decision, part of the decision the party wants reviewed, enter into the name of the court, the date of entry, presenting the entry of your state, issue and present review, part 2, form 6, suggesting the framing, issue and presents a review. See, the store is 20 miles thick, approximately a moving nuclear bomb with a nuclear warhead, and it won't do nothing to it. So you're gonna have to submit this online. Rule 4.2B. So you can send as many terrorists or any homeboys as you want, because the explosive device is going to be downloaded and submitted on the state form document for direct review. Rule 4.2B. Respectfully submitted with signature, name, address, telephone number, Washington Bar Association membership number, and also the effective supreme of the effective date of September 1st, 1994. Title page for the briefs, petition for your review. And you do your location with your location of origin of your UBI number. You got jewelry all over you, and apparently you got white diamonds, black diamonds, you got Russian diamonds, and you got high quality diamonds, and you got gold, silver, white gold, platinum, and also you got the, that platinum looks like you took that off a Cadillac converted from California. You must have ran in some individuals that tried to, of course, on this document, this is Statement of Review, Ground Direct Review. It's Rule 4.2B. So we're going to have to do the description of your worth EGNA history, which you'll download you on a PDF and put it, submit it, and scan it. And you send it out Andy Miller at CO Benton, Washington, U.S. That's describe your work. And it says describe your work here. And it's bottom. You have your initial small caps, little caps, and also your initiated swipe, fingerprint, sensor, whatever the facial, we got to be in front of your monitor or whatever the case might be, to make sure that your jet and fuel and your mileage and also your jury duty increment, your bar, and also your, where is that document? Where is that document? It's right here. You can just scan it on your computer, actually. See, this document says ballot form, the presidential primary official ballot form. This ballot presidential primary, and it's, oh, it has a signature. Oh, there he is. There's Donald Trump. There he has his, oh, his room number, his address, his phone number right here. See, it's all right here. The red line is unbelievably protected in so many ways and shapes and forms. The, how would you say, the, you keep your individual sarcasm to yourself and do the best you can the next day after day every time you wake up, because you have nothing but individual time on your mind, and also in your willing efforts to better yourself as 1,000 calories a day. You want to weigh 130, 105 pounds, 99 pounds, and wear a size 5. You got to improve yourself as a better individual, and so much factors in saving your money and not wasting your money at Red Lion or no. Let's go or the Kavanaughs or the steakhouse and buying ribeye steak when you can go in the backyard and take a combatant military issuance, elite force, Army, Navy, Air Force, Marines sword and cut it off and make sure you got to kill this cattle and make sure you shoot them right above 1 inch above the eyeball. And the quality of the blood flow coming of the heart of the live cattle, and stringing it up by chain and putting it up by a cherry picker, of course Ford Company or Lamb Weston, and you gut it and make sure it's pierced heart and tapered out and blooded properly. And if you shoot it once, twice, 3 times, I have nothing to do with it. You shoot it once, that's good. Twice, 3 times, you're fired. You're non-existent. You can just get out of here and go promote some more business at a drive-through business maybe. Maybe you can go over there and tell everybody what happened, because you can't execute cattle and provide food for the community because you don't know how to kill and protect the domain of the community and services for the staff members, and feeding and preserving, controlling all of their incomes, what goes in their intake system, and give them antibiotics and also give them their vaccination in September, October, December of 2019. If you didn't do that, they wouldn't be alive today. There's 1 million, 2 million factors right now at that peak. It's just because of that. Just because you didn't wipe down their equipment when they were exercising, and you didn't rotate them and deliver their paperwork front, center, and of course delivering it to them. And you definitely didn't take them to Red Lion and pay for all their services, or take them a brand new vehicle and some new keys, insurance, and their driver's license or enhancement services where they can go anywhere in their service and swipe their card and have it activated, just showing up at their business or residence. It says the name of the party, and also said a name, address, telephone numbers, and it's active with the State Bar Association's online membership number. And it's all effective. And this title and page of all brief editions is a review. So we're going to put this down. We're going to download this. We're going to put this right now. And that's activated. Now we're going to have to download it. When you submit it, you save it at that moment. It'll have a logo with a lineman on a Benton POD bill or a Vista utility or a Grunt Tower, whatever the case might be, because the casinos are... Yakima Reservation is the entire state of United States of America. They just have names like Colville or Colville, Davenport Hotel, Ralph Ruscio, whatever the discretionary might be, because it says, starting your work at Benton POD today, and says, do you have to share that life event of carrying combat boots and lining services like White's boots or Lyman boots, which are contrary, you can attach your razor blade nipple points like Columbia Point golf course and put it on your boots or line of boots or attached boots and walk on all the way to the pole and disconnect their services because of the statement of the grounds on direct review form 4. The Supreme Court of the Washington State, Washington says title of the court proceedings without parties to signee at Rule 3.4. It says statement of grounds, a direct review by the Supreme Court. It says the name of the party seeks the direct review, a described decision, part decision the party wants reviewed. Enter by the name of the court, the date of entry, the issue presented a review of R. Now you take your scope and you take your night vision goggles and you present this evidence and you put it onto the desk of Andy Miller's office with the review of Washington Bar Association. It says, the part 2, form 6. For the suggestion of framing issue presenting for the review. Presenting, and this is number 50, 50 cal is like number 50, the 50 ordinance, the 50 cal, the 50 full automatic 50 cal, or the Nitro 500, very popular to all Vietnam vets knowing what a 500 Nitro is. There's a 50 cal, and there's a 500 Nitro. Most of these Vietnam vets don't know what it is because they had a stroke or heart attack, and they see my face, and they know I'm Felix Barela, but they see that 500 Nitro and the 50 cal emblems that are engraved around my neck, Now remember Form 4, Statements of Grounds of Direct Review. Any of these individuals know the Supreme Court of the State of Washington title increments entire proceeding because on the Benton POD bills, any vista utility bills, and there's services, whatever the case might be, on the UBI issuance, it says start to work. So do you want to share that live event? Do you share that important moment in lifetime? It says news feed, and you said submit. Now you got an update button, you got an edit button, which is edit workplace service. You got the sense of time, day, origin, location, dates, and you scroll. And then this browsing system is Andy Miller at Cimaron, Washington. And you got the day. Now you got the workplace would be a Vista utility, Mission Street, Moslek, Washington, where it was built by Amarella AM Irrigation, by the hands, tools, equipment, and aviation equipment, Army, Navy, Air Force equipment, and also the Coast Guard equipment, which is aviation equipment. That's water ordinances. This job title, of course, you have to put your job title, and then your location, and also your year. So when you're crawled out of the vagina of a Class A uniform, and presence of Mr. Anderson, of course, because he wants some, because he's a prosecutor of Washington. He has to do his job, make sure the all the intestines, the stomach of the mile is pulled around off my neck, and then left at the Tri-State Herald for exposure, because that's his job. That is his job, Tri-State Herald. And you put submit, and you submit it, download it, and then you do catch-22, you hit edit, workplace edit, and you also put your initial, describe your work, and first, last name, driver's license, UBI number. It's online. It's all done. And discretionary depressions and your increment life size process are very simple. It takes 5 seconds, really simple. And they have discretionary, first name, last name, bar, UBI number, and fingerprint, swipe fingerprint, and initiation of being in front of your device. And give me that'd be 3 more minutes. That's because of the downloading the physical address and your stipulation report, your conference, your equipment, the ongoing phone call record, and then the state, the zip code, and then the areas of domain, firewalls, which all areas are paid in full, postmarks, states, Department of Transportation, of course, because they want their money, and also the increments of leisure tax of the Social Security Office, front lines, and they have the county and your zip code. And there you go, you should save. And that should be on Hilter. Now you can have a scroll bar, go about, and then you go see info, and then you go back adding in there, which is, that should take care of it. Look at your detainment, and also you got your Richland City Hall for your background on your manifest record, on your UBI administration, on the City Hall. And they have all that software, and that software is there. It's just that it's there. It's a box. It's a monitor box, and that information saves all the information on the services. Richland City Hall is north. Richland Hills, there's Rails Hill. There's Richland City Hall. Richland City Hall with a logo. Richland City Hall, Washington's put Washington, make sure that it is effective. Okay, Richland City Hall has a logo and the job title and your location and also your year, and that's on your UBI business UBI. That's your ID, military issue service or whatever discretionary discount services for your military or VF. The veteran, and that's Senator McCain. That McCain abstract run record runs from Arizona and Air Service. And then it's officially date of birth and location of ordinances, because you have discount services, some services for on any supplies, wardrobe service, anything. And also your land. And there's a land that farm bill is paid 18 years, 2038. 2038 is a long, long time. 2038 is a long, long time. Watch state bar session when you're insurance. You press save, and it puts submit, newsfeed, update save, start working, and whatever, Richland City Hall. And this downloads your service information. Look your power generators, Grant Towers, Administration Office, and it is done. It only took, 4 or 5, 7 minutes. When people tell you one thing or another, it says, this is where number C steps in, because it says, number C, issues presenting for review. Define an issue, what the court asks decide if the review is granted. C part 2, form 6, for justice for framing, issue, and presenting. Okay, this is 2x4s, planking, rebar, plumbing, etc. And they're just framing, just making up, avoiding the situation. They're walk around, they're avoiding this signature on discretionary review is public 5.3b. This is official, not support, because of the support of the Superior Court of Washington for the county, Benton County, plaintiffs, and also the Seattle, Tacoma, Spokane, and also the Kennedy building. This name of party seeking review, plaintiff and defendants, these are equipment. Seeking review, and this is Verizon emblem that's all over the coroner's office, is in front of Benton County Justice Department. Can't miss it. It should be Justice Department, not the logo of Discovery makeup. It should be a logo of Benton County, and also the staff members and all. This is party seeking review. Describing decision, important decision, which party reviewed these samples. This is denying discovery, paragraph 4, and this service entering or entering. This is the discretionary part. Signature attorney of plaintiffs of defendant. Name, address for state bar association member. That's all it took. It's only one.
What are these here? Online?
It's only 1:58 p.m. and this is April 8th, Wednesday, 2020. And that farm bill's paid out to 2038. That's a long, long time now. That's long. That's pretty sad, right? That's shit. You know, that's all it took. All that money, all that college you paid for could have paid that for $5. You could have got your educated for $5 instead of millions, billions of dollars of stipulations and distractions that they're avoiding you.